Welcome everyone to the 9:30 agenda of the Joint Judiciary and Commerce and Consumer Protection Committees. We have two bills up for decision-making only. The first one is HB 1539. This does a number of things: increases fines for violations of certain traffic laws and requires motor vehicle insurance minimums to be increased. Establishes minimum and maximum sentences for persons convicted of violations of certain traffic laws. Amends the minimum liability coverage thresholds to unspecified amounts. Establishes a separate prohibition on driving motor vehicles having noisy mufflers on public highways and high-density areas. Establishes separate fines for violations of motor scooter and motor vehicle muffler regulations. Defines high-density areas and some other stuff. Long and short of it is, it has a effective date already. Recommendation is just to make technical amendments. Questions or concerns? Yes, Senator Elefante.
Thank you, Chair. I'll be voting with reservations. I was on the committee previously on transportation, and one of my concerns specifically had to do with the minimum bodily insurance liability and the levels in the committee report. It did put $25,000 per person and $50,000 per accident. The concern I would have is that number increasing, but I know it does, your recommendation is with tech with still a bad date, so I'll be in support, but with reservations. Any increase on those numbers, I don't know if I could support. Thank you.
Okay, thank you. Other questions or concerns? Question?
Similar concerns with respect to that particular provision, reservations.
Okay, thank you. Anyone else? Seeing none, Senator Garrett for the vote for JDC.
On HB 1539 to pass with amendments, Chair Rhodes.
Aye.
Vice Chair Rhodes, aye. Senator Elefante.
Aye with reservations.
Senator San Buenaventura, excuse. Senator Hawai'i, excuse. Measure passes.
And for CPN, same recommendation, passing with amendments. Chair votes aye.
Thank you. Vice Chair also, votes with reservations. Senator McKelvey is excused. Senator Richards?
Aye.
Senator Awa is excused. Your recommendation is adopted.
Thank you very much.
And I believe the next one's yours.
And for the final measure on this agenda, HB 2415 HD2 SD1 relating to the Nurse Licensure Compact. This measure authorizes the governor to enter the state into the Multi-State Nurse Licensure Compact. Members, noting the effective date on this measure, the recommendation is to pass unamended. Any discussion?
Oh, Senator.
Oh, we actually have text, so the recommendation would be to pass with amendments, technical in nature. Any discussion? Senator Elefante.
Thank you. Chair, I'll be voting with reservations on this. I know there's a lot of support for this, but on the opposite end, there are some concerns raised by some testimony that it may have the opposite effect, where we may have local nurses potentially leaving rather than more coming in. So we'd like further dialogue on that. So with that, in support with reservations. Thank you.
So noted, thank you. Any other? Senator Richards?
Yeah, same comments that Senator Elefante just made. I appreciate where the direction is, but I think further conversation is warranted, and I'll be voting with reservations.
Any other discussion? Thank you. This is the Nursing Licensure Compact. Okay, if there are no other comments or questions, then the recommendation is to pass with amendments, and the chair votes aye.
Thank you. Vice Chair also votes aye. Senator McKelvey?
WR.
Thank you. Senator Richards?
Reservations?
Okay, Senator Awa is excused. Your recommendation is adopted.
Okay, JC member, same recommendation. Any other questions or concerns? If not, Vice Chair.
Chair Rhodes.
Aye.
Vice Chair Rhodes, aye. Senator Elefante.
Aye with reservations.
Senator San Buenaventura and Senator Hawai'i, excuse. Measure passes.
Okay, I think that concludes
Thank you very
the
much.
business. Thanks for being here. We're adjourned. Okay, welcome everyone to the Judiciary Committee hearing for one bill, HB 1968. Expands the time period by which a civil action for childhood sexual abuse committed on or after July 1, 2024 may be initiated. Authorizes court to require personnel of legal entities to undergo training on trauma-informed response. First up on 1968 is Lee and Kwok, Deputy Attorney General. Good morning.
Good morning. Good morning, Chair Rhodes and members of the committee. I am Deputy Attorney General Lee Ying Kwok, and I represent our department with respect to HB 1968 HB2. While our office does not discount the right of survivors of sexual abuse to initiate lawsuits and to seek their own justice, we do have some concerns with quadrupling the time period contained in the proposed statute of limitations. The type of sex assault lawsuits that my division handles would usually follow this format. The plaintiff sues the state, alleging some kind of supervisory negligence of the employee who is accused of perpetrating the sexual assault. The plaintiff does not actually sue the alleged perpetrator because the perpetrator is already dead, or they don't have money and are therefore not worth suing. With the alleged perpetrator gone and witnesses from decades prior being deceased or relocated or otherwise missing, the state has no witnesses to refute the plaintiff's allegation and defend its case. And if the state cannot defend its case, a mere allegation may be sufficient to allege damages, and these are damages the state are responsible for paying. If this committee is still inclined to raise the time period of the SOL, our official suggestion is to raise it from 8 years to 15 years instead of 32 years. This less extensive period will ensure a greater likelihood that the plaintiff will be actually able to face their perpetrator to demand justice instead of suing large parties only tangentially associated with the perpetrator. This less extensive period will also make it more likely that documents are still in existence to be used as evidence, and that there will be witnesses that the state can use in their defense. Thank you for the opportunity to comment.
Thank you. Next up is Michael Gloria Jr. for Stonewall Caucus for the Democratic Party of Hawaii, maybe on Zoom.
They're not present on Zoom, Chair.
In support, next is Evan Oe. In support, thank you. Next is Allison Uyaoka for Hawaii Insurance Council. In opposition, Angela Mercado, Executive Director for Hawaii State Coalition Against Domestic Violence. In support, Raymond Folan, PhD, testifying for the Hawaii Psychological Association. Then there's 1, 2, 3, 4, 5, 6, 9 individuals in support. Would anyone else, that's everyone who's signed up to testify on HB 1968. Would anyone else, yes, come on forward. Good morning.
Aloha, Committee. Angela Melody Young, testifying on behalf of Kapalama Neighborhood Security Watch, a safety initiative, a grassroots of Honolulu Police Department. And I just want to testify in strong support. And to read the science of childhood abuse and also provide research to guide priority policy decisions to focus on trauma-informed care responses relating to the statute of limitations. So children may delay disclosing abuse due to cognitive development, limited ability to understand what happened, or limited ability to explain an abuse. The neuropsychological effects of child abuse studied shows results of patterns in cognitive development. Deficits in short-term verbal memory are observed in adults with childhood sexual abuse. Distractibility, impaired sustained attention are observed in abused children, and a higher prevalence of isotone temporal lobe epilepsy-like symptoms. Together, these findings and others support the hypothesis that abuse has a detrimental effect on brain development. 1/3 of those experiencing childhood abuse have a lifetime diagnosis of illness, while others may never experience illness. So in order to protect youths and children from exposure to this kind of adverse childhood experience, it starts with creating safer boundaries and raising awareness about healthy boundaries with other people so children don't get too close to bad people. And although this is a social practice in the community, policies can be created with social service organizations to provide resources and training for adults and counselors to address trauma-informed care, stigma, discrimination rooted in false beliefs associated with childhood abuse. And with further research, it shows resources for economically disadvantaged neighborhoods should be of priority because neighborhood poverty and family economic well-being are social determinants of childhood abuse. So when policy provides resources to help equip and empower adults to recognize abuse in children, this will solve the issue of statute of limitations because children will be trained to respond and report to the appropriate authorities.
Okay, thank you. Would anyone else like to testify on HB 1968? Okay, seeing none, members' questions? I do have a question for the Deputy Attorney General, if you don't mind. So the argument is often made with regard to bills like this one and similar ones that the passage of time hurts the respondent. I mean, the burden of proof is still on the plaintiff, right?
It is, but
So you're concerned, so the AG's experience has been that it actually advantages the plaintiff to not have any witnesses.
specifically the detriment to the state for prolonged litigation like this. And by prolonged, I mean lawsuits that are filed, 1, 2, or 3 decades after the occurrence of the conduct. Our experience is that
I'm sorry, can you just pull the mic a little farther forward? Thank you.
so one of the bigger issues that we have is document retention. During the course of litigation, there will be discovery requests for documents. And a lot of the time, these documents may or may not exist because of, the passage of time. And
Okay.
some of these documents may have been critical to the state's defense and could have, been used to defend state's position or rebut some of the allegations. But because of the passage of time, these documents are just not available
But
or digitally not stored.
The plaintiff in a civil case, they can't demand a jury trial, can they?
I'm sorry?
A plaintiff in a civil case cannot demand a jury trial.
Not if the lawsuit is solely against the state, but if they involve a co-defendant who is an individual, then they can have a jury trial.
The plaintiff can,
Yes.
by right, can.
Yes.
Okay. I knew the defendant could, I just was, okay. Okay, thank you. Members, other questions? Okay, seeing none, if you're ready to go to decision-making, so am I. In this case, the Senate version of the same bill has already passed out of its last committee, so I'm going to defer this one. We don't need two vehicles this late in the game, so if that was deferred, and that concludes this agenda. We're adjourned for a few more minutes. Okay, welcome back to the Judiciary Committees. We have a series of DM decision-making only agendas, starting with our 10 o'clock agenda. On this one, we have, first up, we have HB 915, updates the Uniform Probate Code by reducing the number of required publications of a notice to creditors by trustee to once a week for 2 successive weeks, consistent with amendments made by Act 158 of 2023. Having taken into consideration the testimony from when we heard the bill and on consultation with the judiciary, I've decided to go ahead and recommend that we pass it unamended. Questions or concerns? If not, Vice Chair.
Chair's recommendation on HB 1915 is to pass unamended. Chair Rhodes?
Aye.
Vice Chair votes aye. Senator Elafante?
Aye.
And Senators San Bonaventura and Nawar are excused. Measure passes.
Thanks very much. Next up is HB 1916 relating to the disclosure of personal information associated with certain public servants. We heard a proposed SD just a second. Yeah, we heard a proposed SD on this. This bill is to hopefully provide some protection for judiciary and executive and legislative branch personnel who sometimes are threatened as part of their job. So a recommendation is to accept the proposed SD, but there are a number of additional further amendments. We'll remove the protections from the state's address confidentiality program and create a new chapter that prohibits government agencies, persons, and organizations from disclosing on the internet the protected personal information of public servants upon request of the public service servant or their representative. I'm sorry, is it still the public servant? And add the Chief Judge of the United States District Court for the District of Hawaii as a person who can designate another person for good cause as a covered public servant under this measure. Require that the government agency, person, or organization removing the protected information from must remove the information, the protected information from the internet within 3 business days of receiving a request to remove with the possibility of an additional 10 business day extension. Require that a request to a government agency to remove be made by the covered servant's department head, that it identifies the specific government record or indexed, and this is just for the government agency, so that it identify the specific government record or index document number that request be made no more than once a month, and to include all covered public servants in a single request with the possibility of additional requests in exigent circumstances. Eliminate the offense of unlawful publication of personal information, but it allows the covered public servant or family member to bring an action seeking injunctive or declaratory relief with the person or organization required to pay costs and attorney's fees. And in the case of a government agency, no cost or fee shall be awarded. Okay, we'll provide for exemptions from this measure for protected personal information voluntarily published on the internet, records on abandoned property, information subject to disclosure pursuant to court order, filings made pursuant to Chapter 490 of the Uniform Commercial Code, and recorded judgments. Also exempt will be copies of recorded instruments affecting title to real property provided by the Bureau of Conveyance to a title insurance company, or that is provided by a title insurance company to a government agency. Also exempt records provided by a government agency to another government entity, provided that the records are not publicly available on the internet. Also exempt information that is part of a news story, commentary, editorial, or other speech on a matter of public concern. And further exemptions with provision or disclosure of information pursuant to the Fair Credit Reporting Act, Graham-Leach-Bailey, Health Insurance Portability and Accountability Act, and the Driver's Privacy Protection Act. And it will also exempt publications of notices that are required by law. We'll eliminate and amend definitions as required by the amendments, and we'll we'll put on a good date, October 1, 2024. And where there may be some inconsistencies between the SD1 and what I've just read, we'll go with the what I just read. I believe is the way we're going to do that. So, and probably I should have said this at first, but the idea, well, I did say something about it, but this bill will cover specifically judges, both federal and state, members of the legislature, high-level executive branch, election workers, and volunteers, and it will also allow the head of each of those organizations to designate additional people if there's a good reason to do so, if they're being threatened for some reason. So that's the recommendation. Questions or concerns? If not, Vice Chair.
Chair's recommendation is to pass HB 1916 with amendments. Chair Rhodes.
Aye.
Vice Chair votes aye. Senator Elafante.
Aye.
Senator San Bonaventura.
Aye.
And Senator Watt's excused. Measure passes.
Thank you very much. That concludes our 10 o'clock agenda. We'll go ahead and roll on into our 10:01 agenda. First up on the 10:01 agenda is HB 1529. This allows burial council members whose terms have expired to continue in office as a holdover member until the member's reappointment to a second term is confirmed or a successor is nominated and appointed. Prohibits holdover members from holding office beyond the end of the fourth regular session of the legislature following the expiration of the member's term of office. It also allows burial councils to allow council members and the public to participate in public meetings remotely. The recommendation here is to pass with an amendment. We've determined that the ability to do the remote meetings is already in statute, so we're going to remove that provision and then we'll make it effective upon approval. Questions or concerns? If not, Vice Chair.
Recommendation on HB 1529 is to pass with amendments of the members present. Any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 1611. This requires law enforcement agencies and the Law Enforcement Standards Board to consult the National Decertification Index and report certain information related to a law enforcement officer's certification status to the index. The recommendation here is to pass with some amendments that I do have prior concurrence for. We'll add language to clarify that the purpose of the Law Enforcement Standards Board consulting the National Decertification Index is to determine whether an applicant or employee is listed and to review any information about that purpose and about that person. We'll amend the requirement that the board report to the index when it opens a disciplinary investigation of a law enforcement officer to instead reference the board's current investigative authority by stating, quote, when the board opens an investigation into a law enforcement officer does not meet the minimum, sorry, it's awkward sounding. The board opens an investigation into whether a law enforcement officer does not meet the minimum standards for employment. There'll be some text, and we'll make the bill effective on July 1, 2026 for consistency with another bill. The important amendment is the one having to do with specifying that the board is only, the current investigation of the board means into whether a law enforcement officer does not meet the minimum standards. So they do not get to open up, and they don't get to second guess the regular disciplinary process of the police departments. It's just looking at the, oh, okay, I'm sorry, for the effective date, so we'll make the bill and the internal effective date July 1, 2026, 2 dates. Questions or concerns? If not, Vice Chair.
On HB 1611, Chair's recommendations to pass with amendments of the members present. Are there any no votes or reservations? Hearing none, the measure passes.
Okay. All right, we'll go ahead and roll on into our 10:05 agenda. And that was all the appetizers. Now here's the main course. HB 1527 is first. It prohibits animal owners and their employees from performing any surgical procedures on the owner's animal or animals, provides that the violation of the prohibition is a Class C felony, clarifies that the offense of cruelty to animals in the first degree does not apply to accepted veterinary practices when the practices are performed by a licensed veterinarian, repeals exemption of cropping and docking as a customary practice under the offense of cruelty to animals in the first degree. Okay, recommendation here is to pass with amendments. In section 2, we'll designate the criminal penalty as a misdemeanor, which is very similar to what is already there, but just for simplicity's sake, we'll just call it a misdemeanor, which has a separate definition elsewhere. We'll add in the committee report that the penalties only apply to pet animals and therefore by definition do not apply to livestock. We have some technical amendments and we'll make it effective upon approval. Questions or concerns? Senator Elefante.
Thank you. I appreciate the amendments. It sounds like it does take care of some of the testimony as it relates to livestock practices where it wouldn't apply to that. So with that, I'll be voting in support. Thank you.
Great, thanks. Other issues, concerns? If not, Vice Chair.
On HB 1527, recommendations to pass with amendments. The members present, are there any no votes or reservations? Seeing none, the measure passes.
Thank you. Next up is HB 1554. This expands the Department of Land and Natural Resources rulemaking authority to include any rule to impose restrictions or requirements deemed necessary to protect aquatic life. Recommendation here was to just go ahead and make it effective upon approval, but yeah, that's it. Make it effective upon approval. Questions or concerns? If not, Vice Chair.
Recommendation on HB 1554 to pass with amendment. Are the members present, any no votes or reservations? Measure passes.
Thank you. Next up is HB 1578. This permits a shipping container chassis that holds a valid out-of-state certificate of vehicle registration to obtain a certificate of safety inspection. Recommendation here is to pass as is. Questions or concerns? If not, Vice Chair.
On HB 1578, recommendation to pass as is. Are there any no votes or reservations? Seeing none, the measure passes.
Thank you, members. Next up is HB 1597, clarifies that members of the public may sue a board or alleged board after receiving an adverse Office of Information Practices decision, and the decision will be reviewed de novo. Establishes a 2-year statute of limitation to bring the lawsuit, and reaffirms the complainant's right to seek review by the Office of Information Practices first, and does some other thing. Well, I guess since I'm okay, recognizes that only a member of the public may recover attorney's fees and costs if that person prevails in an open meetings lawsuit. Requires a person suing for open meetings law violations notify the Office of Information Practices about the lawsuit so that it may decide whether to intervene. Requires open meetings lawsuits that seek to void a board's final decision to be prioritized by the courts. The recommendation here is to pass as is. Questions or concerns? If not, Senator Gabbard.
On HB 1597, recommendation to pass as is. Members present, any no votes or reservations? Seeing none, the measure passes.
Okay, next up is HB 1598, requires boards to make available for public inspection board packets if created at the time the board packet is distributed to board members, but no later than 2 days before the board meeting. Carves out an exception by allowing public testimony to be distributed to board members within 2 business days before the board meeting. Requires boards to include in the notice of persons requesting notification of meetings a list of the documents that were compiled by the board and distributed to board meetings before a board meeting for use at the meeting, and requires boards to post board packets on its website. The recommendation here is we would like to accept OIP's amendment on page 2, line 16 to 19. So the board will read, the board is not required to mail board packets. As soon as practicable, the board shall accommodate requests for electronic access to the board packet and then shall post the board packet on its website. And will make it effective upon approval. Questions or concerns? If not, Vice Chair.
Recommendation on HB 1598 is to pass with amendments. Are there any no votes or reservations? Seeing none, the measure passes.
Okay, thank you. We're on to HB 1599. This requires public meeting notices to inform members of the public how to provide remote oral testimony in a manner that allows the testifier upon request to be visible to board members and other meeting participants, recognizes the board's authority to remove and block individuals who disrupt meetings. I'd like to amend it to just make it effective on January 1st, 2025. Questions or concerns? If not, Vice Chair.
On HB 1599, recommendations to pass with amendments. Are there any no votes or reservations? Hearing none, the measure passes.
Thank you very much. Next up is HB 1600. This requires boards to schedule a meeting for deliberation and decision-making on a report by an investigative group at least 6 business days after the board meeting in which the investigative group presented the findings and recommendations of its investigations to the board. Recommendation here is to make it effective upon approval. Questions or concerns? Seeing none, Senator Gabbard.
On HB 1600, the recommendation is to pass with amendment. Are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 1642. This allows an employee or the exclusive representative, if applicable, to file a complaint with the Hawaii Labor Relations Board if the employer fails to comply with Section 7864 of the HRS relating to general employee orientation. Recommendation here is to pass as is. Questions or concerns? If not, Senator Gabbard.
On HB 1642, the recommendation is to pass unamended. Are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 1869. This establishes the felony offenses of misuse of uncrewed aircraft in the first, second, and third degrees. Recommendation here is to go ahead and pass it with some amendments. On page 2, line 17, move the provision on using an uncrewed aircraft to perpetuate a felony into the third degree offense. Instead of it being a Class A felony, it would be a Class C felony. And will also allow for dags and danks for second and third degree offenses. And that's good. Does have a bad date? Yes. Okay, we'll go ahead and put a good date on it to make it effective upon approval. Questions or concerns? If not, Senator Gabbard.
On HB 1869, recommendations to pass with amendments. Any no votes or reservations? Hearing none, the measure passes.
Thank you very much. Next up is HB 1902 relating to emergency management. Clarifies that the governor and mayor's emergency management power shall be consistent with the state constitution. Clarifies the scope of the comprehensive emergency management plan. Clarifies the power of the governor and mayors to extend or terminate a state of emergency. Shortens the duration of price control periods from 96 to 72 hours. Amends emergency management law to protect tenants, mortgagors, consumers, and residents for certain periods of time after the issuance of a gubernatorial or mayoral emergency proclamation. Recommendation here, it has a bad date, which we'll leave. We'll just do technical amendments. Questions or concerns?
Sure.
Yes, Elefante.
I'll be voting with reservations on this. My previous concerns specifically, I didn't state that in public safety, but had to do with the insertion of components of SB 2843 and the impact from some testimony from the credit unions. Thank you.
Understood. Other questions or concerns? If not, Senator Gabbard.
On HB 1902, noting the reservations by Senator Elefante, are there any other no votes or reservations?
Reservations also.
Senator San Buenaventura, the measure passes.
Thanks very much. Next up is HB 1922 relating to wildlife. Expands the Department of Land and Natural Resources rulemaking authority to include any rule deemed necessary to protect certain wildlife. The recommendation here is to pass effective upon approval. Questions or concerns? If not, Senator Gabbard.
On HB 1922, the recommendation is passed with amendment. Are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 1923. This allows overnight camps in operation prior to January 1, 1961 to be regulated via the special permit process. The recommendation here is to make it effective upon approval. I'm sorry, that's an amendment. Questions or concerns? Seeing none, Vice Chair.
On HB 1923, recommendations to pass with amendment. Are there any no votes or reservations? Seeing none, the measure passes.
Thank you. Next up is HB 2071 relating to photo red light imaging detector systems. Provide that any red light imaging detector systems clear and unobstructed recorded image of a motor vehicle's license plate shall be prima facie evidence that the motor vehicle to which the license plate is attached is the motor vehicle for which the license plate was issued. Keeping in mind that that's the only thing that affects all the due process procedures are still in place for these kinds of citations. Recommendation is to make it effective upon approval. Questions or concerns? If not, Senator Gabbard.
Recommendation on HB 2071 is to pass with amendment. Are there any no votes or reservations? Seeing none, the measure passes.
Okay, thank you. Next up is HB 2090, beginning on January 1st, 2025, allows residential uses in areas zoned for commercial use to be considered permitted under certain circumstances. Requires no later than 1/1/25 each county to adopt or amend its ordinances to allow for adaptive reuse of the existing commercial buildings. The recommendation here is go ahead and make it effective on January 1, 2025, which is an amendment. Questions or concerns? If not, Vice Chair.
Recommendation on HB 2090 is to pass with amendment. Any no votes or reservations? The measure passes.
Thank you. Next up is a sort of an omnibus bill on mental health. It requires the Department of the Attorney General to assist with the preparation and filing of petitions for assisted community treatment and with the presentation of the case unless declined by the petitioner. It repeals language entitling the subject of a petition for assisted community treatment to legal representation by a public defender, provides a mechanism for the automatic screening for certain nonviolent defendants for involuntary hospitalization or assisted community treatment, authorizes courts to require certain probation violators to undergo a mental health evaluation and treatment program as a condition of continued probation. The recommendation here will depend somewhat on the chair of the Health and Human Services Committee. Let's see.
I'm okay with your amendment so long as you keep a defective date.
Okay, got it. Let's see. Oops, sorry, I went too far. Okay, so we'll amend section 334-126 to allow the family court to appoint an attorney for the subject of a petition for assisted community treatment if the interests of justice require one be appointed and if the subject of the petition is represented by an attorney. Sorry, to allow the family court to appoint an attorney for the subject of a petition for assisted community treatment if the interests of justice require one. Okay. If the subject of the petition is not represented by an attorney, or? Oh, okay. Okay. And if the subject is represented by an attorney, whether retained by the subject or appointed by the court, allow the attorney adequate time for investigation. We'll leave the bad date on, which is December 31, 2050. And then we'll keep the provision of custody of the DOH until the ACT petition is ruled on, except that we'll give authority to the judge to order the subject to be released during the pendency of that action. And we'll repeal the sunset for Act 111 session laws of Hawaii 2017 that established the order to treat over objection statute, which is also relevant to this whole, the entire mental health statute. So still has a bad date with those amendments. Okay, great. Any questions or concerns? Seeing none, Vice Chair.
On HB 2159, recommendations to pass with amendments. Are there any no votes or reservations? Hearing none, the measure passes.
Okay, thank you. Next up is HB 2278. This clarifies labeling requirements for macadamia nuts, requires county of origin to be included on the label of a consumer package of processed mac nuts, and allows a private right of action for violations. Recommendation here is to go ahead and make it effective on July 1st, 2024. Questions or concerns? If not, Vice Chair.
Recommendation on HB 2278 is to pass with an amendment. Any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 2295. This authorizes stopping and standing and parking restrictions and prohibitions on property under the jurisdiction of the Director of Transportation and the counties respectively. It specifies that the counties may issue traffic infractions for violations of any law prohibiting or restricting the stopping, standing, or parking of vehicles on all highways and county property. Our recommendation here is to amend it by making it effective upon approval. Questions or concerns? If not, Vice Chair.
On HB 2295, recommendation is to pass with amendment. Any no votes or reservations? Hearing none, the measure passes.
Okay, thank you. Next up is HB 2298. This establishes a timeline by which roasted coffee, instant coffee, and ready-to-drink coffee beverages that use a geographic origin and labeling or advertising are required to contain a certain percent coffee by weight from that geographic region. It currently has a bad date, which I'm going to leave, and it does have, we do want to do some technical amendments. That's it. Questions or concerns? If not, Vice Chair.
On HB 2298, to pass with amendments, Chair Rhodes.
Aye.
Vice Chair votes with reservations. Senator Elafante.
Aye.
Senator San Buenaventura.
Aye.
And Senator Wah is excused.
Thank you. Next up is HB 2342, prohibits carrying or using a firearm in the commission of a separate misdemeanor offense. Also amends and clarifies prohibitions regarding deadly or dangerous weapons, switchblade knives, and butterfly knives. Clarifies hunter education certificates and other written exemptions regarding permit issuing. The recommendation here is to pass with technical amendments and make it effective upon approval. Questions or concerns? If not, Senator Gabbard.
On HB 2342, recommendations to pass with amendments. Any no votes or reservations? Hearing none, measure passes.
Thank you. Next up is HB 2351. This clarifies the annual reporting requirements for the Department of the Attorney General concerning concealed carry licenses. I think there's some issues with this bill that I don't think we're going to be able to solve anytime soon enough, so I'm going to defer that one. Next up is HB 2352, exempts the administrator of the law enforcement standard boards from civil service laws, clarifies membership and certain powers and duties of the Law Enforcement Standards Board, and establishes new deadlines for the completion of board responsibilities. The recommendation here is to add to the Law Enforcement Standards Board a position that is appointed by the union representing police officers, and to make it effective upon approval. Questions or concerns? If not, Senator Gabbard.
HB 2352, recommendation is to pass with amendments. Any no votes or reservations? Hearing none, measure passes.
Thanks. Next up is HB 2400, requires a teacher to surrender their teaching license if the teacher resigns or retires during the pendency of any investigation into allegations of sexual assault, sexual harassment, and other physical abuse of the student. Requires them surrender the teacher's license to be reported to the National Association of State Directors of Teacher Education and Certification. What do we find out on this? Let's see, when's our hearing on Thursday? Game on Thursday? 10 o'clock? Okay. I'm going to defer this one until 10:01 on Thursday, which would be the 4th in this room, 016, so deferred date certain. Okay, next and last is HB 2482. This repeals the requirement for the Office of Lieutenant Governor and County Clerk's offices to timely post paper or electronic copies of all meeting notices filed by boards in a central location in the public building. Instead, requires the office to ensure access to paper or electronic copies of the notices. On this one, I'm just going to put a different bad date on it. So April 14, 2112 will be the amendment, and we'll move it forward. Questions or concerns? If not, Vice Chair for the vote.
On HB 2482, the recommendation is to pass with amendment. Are there any no votes or reservations? Hearing none, the measure passes.
Thank you very much. That concludes our business for the day. Thanks for being here. We're adjourned.